order item number 1 and 2.
Not allowed. Not allowed. You have to go to the Supreme Court, I think.
My lord.
Item number,
Nobody is there for mention today to take down your mentions. Nobody is there. All the staff are busy with the blood donation and eye camp.
Order has been given.
for item number 18 for withdrawal.
If you are any
No, my lord, I wanted to move an application for urgent application for anticipatory bail.
anticipatory bail.
Whether your lordship will permit today or on Monday. If your lordship
On Monday, I think you'll have to mention. Nobody is here in the court.
I have
All
understood.
the staff, all
I
the
know.
ministerial staff are there.
Let it be permitted so that it can be listed on Monday. Otherwise, it will not be listed.
On Monday, huh? Later on Monday.
For listing on Monday, because Monday list has already published, so they can, if your lordship permits, then my lord, it can be listed in supplementary.
Not on Monday. AB not on Monday.
Huh?
Not on Monday. Some other day.
Motion did.
Not on Monday. AB
On 8.
8 on 8 Tuesday. On Tuesday.
Item 18 for withdrawal.
May the lordship, as per instruction from additional lordship, kindly withdraw the matter. 18, yes, lordship.
Who is for item number 18?
I am for,
Learned Counsel, Mr.
on
M.
behalf of Jade Ahmed.
Your name is Jed H. Ahmed.
As Islam, on behalf of Jade Ahmed.
As Islam, on behalf of Jed H. Ahmed has prayed for withdrawal. Learned additional PP, Mr. DP Rusam is present. Petition is dismissed on withdrawal.
Deep level.
Please, Your Lordship.
Etu,
Your Lordship, back to mention item number 12, Your Lordship. Otherwise, I was confused about the order.
Hmm.
Your Lordship, in this case, Your Lordship, we have filed one additional affidavit. The matter may be listed any day in the next week, Your Lordship, on 8th or 9th, Your
etu
Lordship.
details on next week.
12th,
12. Next week, kunba illa khan didiya.
on 9th, if possible, Your Lordship.
10th.
10th, high level. 12th,
Learned Counsel, Mr. M.
IH Lordship.
I.S. Losko has submitted that he has filed an additional affidavit. Received to place the affidavit on record. List the matter on 9th, 10th.
High level, Your Lordship.
Item 3.
May I please, Your Lordship? Lordship, this matter is filed under section 117 and 109. In this case, Your Lordship, the applicant in intoxicated state hurt a person in his head. And after that, he was beaten by the public. He did that in a marketplace, Your Lordship. And he was sent to jail. Your Lordship, kindly come to the paragraph 3, Your Lordship. Page 3.
Brick on his head will need the CD.
CD along with the injury report.
Call for the CD along with the injury report of the victim. List the matter on. You are arrested on 3-9.
3-9.
That person has died.
No, he's all right. He's working.
3-9, how?
Charge has been submitted.
Is submitted, Your Lordship.
Okay.
Case.
Perfect.
Call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on. You applied for bail in the lower court. Have you applied for
We
bail?
applied.
It
It's
has been
rejected.
rejected.
Item 4.
May it please, Lordship. The petitioner was arrested on Lordship 29/1, Lordship. It is my Lord, 67 days, Lordship. FIR is Lordship 10, Lordship, please 10, Lordship. It's the robbery, Lordship. Only suspected ground, Lordship, you are arrested, Lordship. In the FIR,
Robbery. Robbery.
robbery, Lordship.
Dacoity or robbery?
No, robbery, Lordship. 67 days today, Lordship.
How many days behind bar?
67 days, Lordship. But page 10, Lordship. Fourth paragraph, Lordship. My
So CD is required.
Lordship, fourth paragraph, my Lordship. During the course of inquiry, it was revealed that one accused Joel Khan, this is the petitioner, Lordship, was suspected to be involved in the incident. Only suspected girl.
No, but his, that ATM card was found, I think. The ATM card of the woman was found in his house.
But nothing has been recovered, Lordship.
Okay, then
Hatika,
robbery, I'll just check the sections, okay?
3094 is 90 days, extend to 14 years.
no, stay there.
3094.
Four. ৰবাৰী যদি হেৰি হাইৱে বা হেৰিয়াত হয় তেতিয়াহ'লে ৰাতি হয় তেতিয়াহ'লে ছানছেটৰ হেৰিয়াত হ'লে 14 years. নিয়মটো হেৰি হ'ব 10 years লৈ হ'ব।
Maybe.
বন্ধটো নাই।
That lady's ATM card was found in your house.
Considering the length of the detention, Lordship.
Mrs. Biju Sharma. One SBI Global debit card belonging to Mrs. Biju Sharma bearing card number. One SBI debit card of Sri Nipendra Sharma bearing card number. And some items, one money bag which contains said ATM cards was found.
No personal jewel from his mother, from his home, his mother.
Then
Yes.
there is a murder case also against him. 304B. Dowry debt.
And 392 also there.
Another
Another case.
392
It is
case.
another case.
We'll call for the CD.
Hatika, Lordship.
Call for the CD, list
Next
the
week,
matter
okay.
on. One Hatigaon PS case under section 392. One dowry debt
304B.
case. I think people will be safe without him.
Item 5,
May I please, your Lordship? Lordship, one AV number 245 public 2025 in connection with the same PS case is fixed on 8/4/2025 for cash diary.
Okay, call for the CD, list the matter on. Along with case number,
Two
AB
for
case number.
AV number 245 public 2025. Lordship, item number 9 also same.
Okay. This is item number
-9. Obliged.
9 ও আগে লিখি দিবা।
item 6,
Regular bail application petitioner is arrested on 26/3, 11 days today. Lordship will find the FIR page 11. I'm not commenting on merit of the case, but he's been arrested on page 11. Merit.
Mhm.
Respectfully, I beg to state that I am an employee of the postal department. At present, I am working in the post of OS mails at North Lakhimpur West Subdivision. It is to inform you that on 31/10/2023, Sri Srimanto Bora, the accused here in Malad, son of so and so, got appointment in the BPM.
Okay, okay, okay. Okay. You want a CD?
My lord,
He is behind bars for how many days?
11 days and all the documents that has been seized. In
Okay,
fact, he
okay,
is
okay. I'm trying to wait. Third learned counsel, Mr.
P. Hazarika.
Huh?
P. Hazarika.
P. Hazarika for the petitioner Simanto Bora, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as the petitioner is behind bars since 26/3/2025 in connection with so and so PS case under so and so section. Third, Mr. DP Uswami, learned additional PP Assam. It is submitted on behalf of the petitioner yes, what do you want to say? You said something? You have said
Well,
something?
all the documents that has been seized. In fact, he has voluntarily
That
submitted all
all
the
the,
documents.
that all the documents which allegedly has been fraudulently used by the petitioner to procure his employment at BMPM or what?
Yes, madam, the BPM, my lord.
Or at BPM has been seized in connection with this case. The petitioner is also willing to cooperate with the remaining part of the investigation. Considering all aspects, petition is allowed. A full stop detail, the allegation against the petitioner is nalage to assay no center. The petition is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned CJM
Citizen
Lakhimpur.
Lakhimpur. Yes.
under the condition that the petitioner shall cooperate with the remaining part of the investigation and the petitioner shall refrain from such activities with which he is alleged. And number 3, the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioner.
I am public.
Item 7,
May I please, Lordship? Lordship, I am not FIR name accused, Lordship, first of all.
Mm.
So, FIR is at page number 11. Lordship. Page 11, vernacular.
Mm.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 12/2/25 তাৰিখে ৰাতিপুৱা 4:30 মান বজাত মই মোৰ স্ত্ৰী আৰু সৰু ল'ৰাজনক লৈ গুৱাহাটীৰ পৰা দিল্লী অভিমুখে উৰাজাহাজেৰে যাত্ৰা কৰোঁ। দিল্লী, কানপুৰ, ইন্দোৰ আৰু কলিকতা আদি যাত্ৰা কৰি যোৱাকালি 22/2/25 তাৰিখে ৰাতিপুৱা 10 বজাত মোৰ বাসস্থান আহি পাওঁ। ঘটনা মৰ্মে মই যোৱাৰ সময়ত মোৰ আন এজন ল'ৰাক ঘৰত থৈ যাওঁ দোকান চলাবলৈ আৰু মূল দুৱাৰৰ লগতে আলমিৰা আদি তলাই লগাই যাওঁ। একমাত্ৰ পাকঘৰ খোলাৰ কাৰণে চাবিকাঠি ল'ৰাজনক দি যাওঁ। উল্লেখ্য যে তাৰ লগৰীয়া উপৰোক্ত ল'ৰাকেইজনে খানা খাবৰ কাৰণে মোৰ ল'ৰাজনৰ পৰা চাবিকাঠি লৈ যায়। পাকঘৰৰ আটা থোৱা পাত্ৰ এটাত চাবিকাঠি থোৱা আছিল মূল কোঠাৰ তথা আলমিৰাৰ, য'ত নেকি নগদ টকা 48,000 to 50,000, এডাল সোণৰ চেইন 3 তোলা, লকেট, হীৰা আৰু সোণৰ মিক্সড এটা, 3টা গিন্নি, এটা সোণৰ আঙুঠি, 3ডাল সোণৰ খাৰু আৰু 2টা ৰূপৰ মুদ্ৰা আদি সকলো অলংকাৰ চুৰি হোৱা দেখা পাওঁ। আমাৰ কোঠাৰ বাহিৰত থকা CCTV মতে তেওঁলোকে 12/2/25, 13, 14, 15, 17 আৰু 19/2/25 তাৰিখে কোঠাত প্ৰৱেশ কৰা ফটো আবদ্ধ হোৱা দেখা যায়। আৰু সেই মৰ্মে তেওঁলোকে উক্ত অলংকাৰ তথা নগদ টকা চুৰি কৰা বুলি সন্দেহ হয়, সেয়েহে মহোদয়ৰ ওচৰত তদন্ত বিচাৰি আহ্বান। Lordship, I am not an FIR name accused. I will cooperate the investigation, Lordship.
Why are you apprehending arrest?
Lordship,
Why are you apprehending arrest?
police is calling me, Lordship, to the police station.
Why?
Lordship,
Why?
because
This has alleged only 4 boys.
one of the accused is Gautam Kuhar. Gautam Kuhar is my business friend. I have a small boutique in the Borolumu. He's my business partner. That's why. So there is an apprehension. I may be arrested. Lordship.
Third learned counsel, Mr.
AK Sharma.
A.K. Sharma for the petitioner, Ms. Trishna Rani Devi, who has filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as they are apprehending arrest in connection, as she is apprehending arrest in connection with so and so PS case under so and so sections. Third, Mr. DP Goswami, learned additional DP Assam. The informant has lodged an FIR on 24, no? 24
24 Lordship.
24/2/2025 after returning from Delhi that there was theft in his house and cash of rupees 48,000 and diamond and gold jewelries were stolen from his house. Through CCTV footage, they have noticed and entry and exit of several miscreants. Full stop. The petitioner is not named in the several miscreants who have been named in the FIR. The petitioner is not named in the FIR. The one of the named accused, what is his name?
Gautam Kuhar.
Gautam Kuhar is the business partner of the petitioner. Now now as the police has summoned the petitioner to the police station, she is apprehending arrest. The petitioner is willing to cooperate with the investigation. It appears that interim bail may be granted to the petitioner. Call for the city, list the matter on. In the interim and in the event of her arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation.
Biplab Rajus.
Item 8,
Next, please, your lord. 3 years bail application, my lord. My lord, kindly turn to page 13, my lord. This is a complaint case, my lord. Although the allegation is of rape, my lord. And the fact of the case is that, my lord,
Informed that on the same date, from the secret information received at the ward number, so-and-so Safiqul Hussain is selling illicit substance at his homes. Accordingly, staff and women constable of police station and driver of so-and-so start their journey, and by reaching at the house of the above mentioned accused at 1:40 p.m. and as per the approval of higher authorities at 1:50 p.m. in the course of search of the house of Safiqul Hussain, on his presence, P1 space plus so-and-so codeine phosphate 41 bottles, meteor, all of these are contraband found. Of suspected contraband has been seized as in the seizure list, and accused Safiqul was arrested, handed to the police station under section 22C. Now, my lords, during the investigation, the place of incident was visited and statement of the accused was recorded. Seized items were examined. From the witness got sufficient evidence against Safiqul Hussain. Second, Rahul Prasad, which is me. Third, Suman Roy. And fourth, Jahirul Islam, who has been given bail by the trial court for the offense under 22C or raid of 29. Well, the brief facts is this, that a police conducted a raid on 14 at the house of Safiqul Hussain. From there, some illicit materials were seized. Subsequently, as per his statement, I was arrested. Now, my lords, the law is clear. In Tofan Singh, as per Tofan Singh, the statement of a co-accused is inadmissible. A. B. My lords, co-accused has been given bail. 3. My lords, I have been in detention for more than for 1 year, 7 months, and 19 days. So, my lords, Article 21.
How many witnesses have been examined?
Let's it's I think 7, my lords.
How many witnesses are yet to be examined?
There are total 13 witnesses. And nothing against me, my lords. It's a trial. Even the Caesar list, they say that has been disapproved. My lords, may I kindly peruse that as well.
You are behind bars for how many days?
1 year, 7 months, 19 days. So, my lords, Article 21, my lords. There's 1 year. This court has been giving, Supreme Court has, there's numerous jump. I will be relying on that as well. That's, I have prepared a short note. That. Excuse me.
Yes, what do you have to say?
Oh, let the other witness may be examined. 6 witnesses remaining be to do it.
I just have all the, I'll be relying on that on all the. I mean, also the section 42 has not been complied with. These are written arguments. And all this judgment, I have the copy of the judgment if my lords.
There's one judgment that the length of detention in serious offences is not a ground for bail.
Your Lordship, but there are also other judgments in this court, coordinate benches, and your Lordship has
Supreme
given.
Court judgment.
Huh?
Supreme Court.
Supreme Court, I have relied on Supreme Court judgment as well. It's,
There's one more judgment that
This is the new trend, my lords. It's a judgment of just 1 month back. An order, my lord.
This orders are not orders are not precedents. These are passing remarks, passing observations.
Yeah, but this court also, if 1 year, 6 months has been passed, Article 21, even your lordship has relied on a judgment in which your lordship has says that when there is a long delay, there is a long incarceration, it is unfettered by the section 37 of the NDPS Act. At the end of the day, the bar is only under the section 37. And here, my lords, I don't have praised this well, but there is nothing in position for my.
actually, very frankly speaking,
Hmm.
your case is not a similar case. Your case is a case where 7 witnesses have already been examined.
And nothing from them, nothing from them.
Within, yes, I understand.
Ah.
Nothing from them. So why don't you wait for acquittal then?
No, my lords, then the question before this honorable court is, my lords, if tomorrow.
I will pass an order, but I
will-
don't
No,
think I
actually,
am
I will-
granting bail.
I will also provide our coordinate judgment lordship.
I'm not granting bail. Why should I make false promises?
No, my lords, because they are
I'll pass
coordinate
an
bench
order.
judgment. There is nothing on the law that, my lords,
I can pass an order inside, but I'm not granting bail.
The BA number
You
BA
have a ground for bail.
24824.
my lords, but there are coordinate bench judgment.
Myriad of articles were
248.
Nothing from me, my
recovered.
position.
I know.
Co-accused has been given bail.
Different types of articles, variety.
But the co-accused has been given
Tablets,
bail. Co-accused,
codeine.
no, just two things, my lords, may kindly appreciate. My lords, I appreciate my lordship. My lords, A, co-accused has been given bail.
I heard you.
B, my lords, here.
Why didn't you see? That is the fallacy. Why didn't you approach the trial court? earlier-
I approached the trial court dismissed.
Rejected.
the case. No, it's the other thing, well, is that I have I have been linked to a main case. In the main case is of Safiqul Hussain, from which there is a possession. Now,
You won't be able to convince me. Your case, actually, yesterday I have granted bail to a person. I have granted bail. He didn't try much to convince me, but I have granted. Because there is a ground. Here you don't have a ground. I'm really sorry. You don't have a ground.
but your lordship has been very kind to grant bails in other cases, my lords. In 1 year, 6 months, you are like,
Ground. You see here.
there's nothing, my lords.
Articles.
Well, in criminal law,
Varieties.
well, if that's the way, well,
Tablet.
I bow down to whatever your lordship
Cough
passes.
syrup.
No.
And then co-accused just named you.
No, your lordship, I bow
And
down.
you are the receiver.
Well, I bow down to everything what lordship passes. That's I bow down to any order that your lordship passes. But the only thing, may kindly appreciate.
I'm so sorry. You see, your argument is very good. You have submitted a very vigorous argument, but I'm really sorry. I'm not granting bail. No point taking. I'll pass an order inside and then I'll reject it. On your face, I'm saying. You submitted a very good argument. Sincerely, you
The
have
only,
submitted
ma'am,
your argument.
the only good arguments are the arguments which succeed.
No. Why? Who said so? This is not true. Arguments are good arguments even when the order comes against you. Third learned counsel, Mr. Disha Agarwala, for a petitioner. So you are supposed to give me a judgment. Who has filed this application for the petitioner Rahul Prasad, who has filed this application under section 483 of the BNWS 2023 with bail for bail and is behind bars since 18/8/2023 in connection with special case number 335 of 2023 under section 22C of 20/29 of the NDPS Act pending in the court of the learned special judge Dhubri. Which page?
Application.
Which page and which paragraph? I did it. Khushi sir. Had Mr. DP Goswami learned additional PP Assam. It is submitted on behalf of the petitioner that the petitioner is behind bars for more than 1 year, 7 months, huh?
19 days.
For more than 1 year, 7 months, and considering the trends of the decision of the coordinate bench of this, considering the trend of the decision of the coordinate bench of this court and the petitioner deserves bail, it is further submitted that is that the
Ten.
rigors of section rigors of section 37 of the NDPS Act does not act as a fetter, does not fetter the bail prayer as there is no evidence against the as one condition here, as one of the condition is that there is no evidence against the petitioner despite despite the recording of evidence of 7 witnesses who stop. It is submitted that 11 witnesses are enlisted in the case diary and only 7 witnesses have been
13.
or 13 witnesses are enlisted in the charge sheet, case diary charge sheet, and only 7 witnesses have been examined, and the possibility of culmination of trial appears to be remote, considering the slow pace of the trial. It is further submitted that the petitioner was ordered to custody only on the statement of the co-accused, which is against the decision of the Honorable Supreme Court which is against
Tufan Singh.
in contravention of the decision of the Honorable Supreme Court in the
Paragraph 4, 10, 12, 13, 15, 20 to 24, and 26.
of the Honorable Supreme Court in Tufan Singh versus State of Tamil Nadu, 2021, 4 SCC 1, wherein it has been observed that the confession statement recorded under section 67 of the NDPS Act shall remain inadmissible in this even at the stage of consideration of bail. The petitioner has also prayed for bail on the grounds of parity, as a co-accused has been enlarged on bail by the learned trial court. And these are the submissions I have recorded.
With section 42. if you're-
Or it is also submitted that the trial has been vitiated as section 47 or 42 of the NDPS Act has not been complied with. On the other hand, the learned additional PP has relied on the decision of a coordinate bench of this court for that 5 years,
Not-
Satendra Kumar until
Not
have the coordinate bench of this court wherein by the order dated 28/11/2024 in connection with BA number 2438 of 2024 in Daniel Ithari versus the state of Assam. It has been held that para 12, para 13, para 12 and 13.
Paragraph 12, 13, 15, 20 to 24, 25, and 26. I've marked it, Lordship.
Para 15. Para 22.
Very elaborate to discuss all the judgment of our Supreme Court, Lordship.
Para 24.
25 and 20.
Twenty-six is not required. This is
I
a news. Para 25. I have considered the submissions at the bar with circumspection, and I have also scrutinized the trial court record. It can, at least at this stage, it cannot be considered that investigation is progressing that trial has been procrastinated by the state or by the court. 7 witnesses have already been examined within within a period of 1 year.
7 months.
7 witnesses have already been examined within a period of 1 year, 7 months.
Detention. Length of detention.
No, not detention. First, when 1 year, 18-8, no? 18-8, 9, 10, 11, 12, 1, 2, 3. Within a period of 1 year, 1 year, 7 months. ঠিক আছে। In offenses of serious nature, the length of detention cannot be a ground for bail. Also, full stop media, also, the ground of parity. Length of detention and the ground of parity, it cannot be a reason for, cannot be ground, reason. Another word for ground and reason. Cannot be a ground for bail. The argument of the learned counsel for the petitioner that the rigor of section 37 of the NDPS Act does not act as an embargo cannot be accepted at this juncture. In the wake of the foregoing discussions, petition with prayer for bail is rejected at this stage. However, the petitioner is at liberty to apply for bail, to file a subsequent bail petition in case the trial is procrastinated by the state or by the court.
Much of all.
13.
So, Hurricane Gusi Gole.
We have received a case diary, but PM report is not available in the case diary.
It will be necessary.
CD is received without the PM report, send back the CD, call for the up-to-date CD along with the PM report, list the matter on after vacation.
So item number 15 also, madam.
Okay.
15 to more. 15.
15 signal tar in our
Here also CD was called for.
CD is not received.
CDS
Lordship,
offer is not
I
received.
have a
we should
prayer
put
in
the-
this case.
Huh?
I have a prayer in this case,
Yes,
Lordship.
yes.
Lordship, here, shown arrested case, Lordship.
Mm.
Lordship, here 47 mandate is not followed, Lordship. 47 is not been given to the petitioner, Lordship. Lordship, I have gone through the case record, Lordship, lower court, and there is no 47 notice.
Accident to, this case is under which section?
Lordship,
50?
sections are 406, 420, 468, 470, and 471 and 506.
You have a ground then. But we'll need the LCR, no?
LCR.
Case record of which has been lying in.
Charge sheet has been submitted.
No, Lordship. But while production, the case records are submitted in the lower court, Lordship. I have gone through the record, Lordship. There is no 47.
Case date, otherwise we cannot wait for.
But Lordship, a short date may be given before Bihu vacation, along with the case record, and the case diary may be produced.
Oh. CDS copper is not received, we should reminder, list the matter on. No, before Bihu,
Before Bihu,
Before me,
Lordship.
it will be
And
difficult to come.
নহয় মানে আহিব
no,
চাইটে
Lordship, here,
this is from which
Nunma TPS, Lordship.
এইটো আহিব দি দিয়া
Lordship, will the case record be necessary?
that 47 is appended with the CD, I think. It
Lordship,
comes with the CD.
Lordship, obliged, Lordship.
Otherwise, you submit a copy if you want.
There is no 47 notice in the record. No, notice has not been
47
served.
in the record.
Yes.
It will be in the CD. 15 হৈ গ'ল না 13 or 15 13 14 15 হৈ গ'ল না?
14 was 14. Please, Your Lordship. Lordship, the FIR is a page number
14, we have received the case.
15, Lordship.
Injury report is not there.
Lordship,
Otherwise,
the-
witnesses are implicated, the petitioner.
Lordship, the allegation is basically that the petitioner, along with two other boys, they used sharp weapon to and caused severe injury to the informant. And why, Lordship, because the informant has asked the petitioner and his two friends to drive their motorcycle safely. But that is not the fact, Lordship. The
There
actual
is
fact is
AB or
different.
BA?
BA, Lordship.
How many days you are behind bars?
Almost 24 long days, Lordship. I'm a 22-year-old boy,
He's behind bars for that
23 days.
23 days.
injuries on that
Injury,
was-
injury report is not available
No,
in the case.
victim is, what has he stated? Victim?
Victim-
Where is the FIR?
FIR is at page number 15, Lordship.
What is the victim stated?
May I read out the FIR? Lordship?
Yes, yes.
This is to inform you that today at about 4:30 p.m., I was coming towards my home at Dokhin near Krishna Mandir. In between, the below noted accused persons has rashly and dangerously rides their motorcycle near Mosjid. I politely objected them for the riding and they became hyper and strangulated my neck with intention to kill me. The local people gathered and they escaped me from the place. After few minutes, they with proper plan and conspiracy hided themselves near my house. I came near my house after buying medicine. They attacked me with sharp weapon and with intention to kill me. I shouted and nearby people gathered and managed to detain the number one accused person and his motorcycle bearing registration number so and so. However, the other two escaped from
What
the
is his
place.
name? Apurva Jyoti?
Gogoi, he's a complainant also.
What has he stated?
Suddenly attacked me and tried to kill me by strangulating my neck.
Lordship, that is not true, Lordship.
And local people detained one person, namely Sapikul.
In the FIR as well as in the forwarding, there is clearly mentioned that severe injury has been caused, even in the ground of arrest, with sharp weapon.
No, see,
Nothing
there
has
are
been seen.
judgments of the Supreme Court that
Nothing has been seen.
when you try to strangulate, here the injury,
Mark.
neck injury may be
Yes,
simple. That neck injury may be simple.
but there will also be a
when-
mark.
No, marks are not required. When there is a ground that neck injury is simple, then if there is an injury on the neck.
But the
then-
actual fact, Lordship, is completely different. I will beg to state the
No,
actual
now
fact,
we-
Lordship.
that we have everything in black and white. There is no actual fact here.
Yes.
Okay, then do you want him behind bars? Can be granted, I think. Our learned counsel, Mr.
M. Ahmed.
M. Ahmed for the petitioner. How many petitioner?
One.
One. Which one?
There is
The
only
main
one.
one.
Yes,
Sapikul
The
Islam.
one who
Sofiqul Islam.
strangulated.
No, the allegation are not specific, Lordship. General allegation.
That allegation, this is not allegation, this is statement under section 161. Which is equal to which is similar to the FIR.
Yes.
So this is a case under section 109, no doubt about it. Sofiqul Islam who has filed his application under section 482, no?
483.
483, okay, he's behind bars.
Behind bars.
483 with prayer for bail as he is behind bars since,
15th of March.
since 15/3/2022-25 in connection with so-and-so PS case under so-and-so sections heard Mr. D.P. Goswami, learned additional PP Assam. It is submitted by the learned additional PP that the injury report was not forwarded along with the CD. There are incriminating materials in the case diary against the petitioner. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioner. Investigation has progressed substantially, although the injury report is not to be found in the CD, full stop. Considering all aspects, the petitioner is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the Larat CGM Kamrup Metro, under the condition that the petitioner shall refrain from such activities with which he is alleged. The petitioner shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not leave the jurisdiction of the court without prior permission, and the petitioner shall not exercise threats to the witnesses or try to influence them. On breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioner.
Lordship,
Send
I
back
have
the
a
CD.
Lordship, I have a humble submission, Lordship.
He is
That-
not a local person.
No, he is a local person. He will be going to get some mobile
Okay,
phones.
to not leave the jurisdiction.
He will be
of the
going to
court.
Chennai, most probably.
Anyway, delete code, yeah. Not leave the jurisdiction of the court.
Deeply obliged, Lordship.
Pen nahi le ako. Yes.
Yes, madam. The FIR is 12, my lord.
Hmm.
But the petitioner is not the FIR person, my lord.
Hmm.
And I'm on parity, my lord. My
Hmm.
ground. In the similar circumstances, my lord,
Hmm.
this honorable court, my lord, granted interim bail, my lord, to one Kobi Ali. I have annexed that order, my lord, at page 14, my lord.
Page 14.
Page 14.
I have granted.
Yes. Well, the case is old pending case, my lord. FIR is of 2023, my lord. At that point of time, my lord, the
Just a moment, let me read the FIR.
Near about 2 years, police has searched him
Hmm.
on 23, 325, police has ready.
notice was not also given to him, my lord. Only visited the house, my lord, and took some document, my lord, pen card and Aadhaar card from his wife, my lord. He's running a clothes shop, my lord. Earlier, he was a driver, my lord. Since 2017, my lord, he's running a shop, my lord. He's not in that profession, my lord. He was a professional driver earlier, my lord. Prior to 2017, my
We
lord.
will call for the CD. This person I have granted interim bail, but not all. I don't
Yes,
know.
my lord, but
There must have been some reason why I have granted interim bail to you.
But he is ready to cooperate, my lord. My lord, on 10 April, my lord, this case is fixed, my lord. Maybe take with that case, my lord. And my in the
Yes,
meantime,
yes.
I may be protected.
Call
my
for
lord.
the CD.
My lord, kindly, my lord.
10th April. 10th April.
10 April.
Call for the
My lord,
CD.
kindly, my
No,
lord.
no.
He is a cloth. He's running a clothes shop, my lord.
On 10th April, somehow you
My lord,
manage-
kindly, my lord. Kindly, my lord.
somehow you keep yourself away from the police 10th April.
My lord, kindly, my lord.
No, no, no.
My lord, item number 16 is my lord POCSO matter, my lord.